Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. A District of Massachusetts court released a ruling in the case against Commonwealth Equity Services, LC, on April 7, 2023, allowing the SEC's petition for summary judgment and refusing the defendant's cross-motion for summary judgment. This judgment, according to the agency, strengthens the SEC's case against Ripple. The SEC sued Commonwealth and CEO John Rooney in 2019 for breaching federal securities laws via deceptive sales techniques, including substantial misrepresentations and omissions of conflicts of interest. The SEC prevailed in the lawsuit. Most notably, the court dismissed the defendant's procedural claim that the SEC failed to give appropriate notice of the disclosure duties asserted in the complaint. Ripple's fair notice claim, according to the SEC, is as inapplicable as it was on the Commonwealth case. The SEC draws parallels with the Ripple case because Commonwealth similarly contended that a 50-year-old Supreme Court rule on disclosure responsibilities was inadequate to warrant fair notice. The court, however, found in favor of the SEC, holding that fair notice was thus provided. First, it holds that lengthy Supreme Court precedent may offer fair notice, which is similar to the SEC's position in this case. That Howey and its progeny presented defendants with sufficient fair notice to defeat their constitutional argument. As a result, the SEC believes that the Commonwealth case offers further authority for dismissing Ripple's fair notice position and granting the SEC's petition for summary judgment. The XRP legal community sees no compelling arguments in the letter. Attorney Jeremy Hogan, as Bitcoinist reported yesterday, sees the technical problem at the core of the case. If Judge Torres understands technology and decentralization, he believes Ripple will win. Australian lawyer Bill Morgan dismissed the SEC's recent letter, claiming that there is no comparison. If you believe there is a factual similarity between selling an asset like XRP in a 13-year-old market to buyers to whom it owed no post-sale obligations, and a case in which an investment advisor failed to make all necessary disclosure of potential conflicts of interest from which it benefited to retail investor clients to whom it owed fiduciary duties and whose funds it managed, you should be concerned about the SEC bringing this case to Judge Torres' attention. According to Fred Rispoli, founder of Hodl Law, the letter is not super on point, but it might cause a longer delay in the verdict. Judge Torres has always granted the opposing party time to reply to the other party's supplementary brief throughout the proceedings. Ripple could file a response in under 2 hours, adds Rispoli, who anticipates some delay. A banking law expert has drawn attention to the problem with using the Howey test to determine whether something is or isn't an investment contract, which could cause the regulator to lose its war against crypto, as the cryptocurrency community eagerly awaits the resolution of the courtroom standoff between Ripple and the United States Securities and Exchange Commission. In fact, Todd Phillips noted a contention from the motion to dismiss in the SEC lawsuit brought against former Coinbase executives Ishan and Nikhil Wahi, which suggests that Howey isn't the best way to determine what constitutes an investment contract. In the tweet thread the legal expert posted on April 8. You also need a contract, post-sale legal responsibilities, and the right to share profit, he said. If this ends up being the litmus test, then it is probable that cryptocurrency assets fall within the purview of the. Aside from its application in other court cases, such as that against the cryptocurrency exchange Coinbase, utilizing this defense would be a serious blow to the SEC's power in terms of more than only regulating the cryptocurrency industry. The Ripple defense team has previously presented this case. According to John E. Deaton, an attorney and amicus curiae for the blockchain business who noted Phillips' tweet on April 9. He added that we are waiting for Judge Torres' decision any day now. The argument was used by Coinbase in its amicus brief in Oahi. Scott Chamberlain, a former attorney and co-founder of the permissionless Layer 2 platform Evernode XRP, had earlier claimed that the lawsuit would have settled long ago if the SEC had just claimed that Ripple had offered XRP as an investment contract, rather than that it was a security. In response to a video of SEC Chairman Gary Gensler shared by Susan Friedman, the International Policy Council at Ripple, Deaton's company Cryptolaw stated that cryptocurrency can't be an investment contract for those who acquire a token on the secondary market, for consumptive use and with no knowledge of, interest in, or rights from whoever previously sold it on-chain. At the same time, according to Feinbold on April 8, Attorney Bill Morgan stated that the SEC's own expert had acknowledged that changes in the prices of Bitcoin B2C and Ethereum, ETH, might account for up to 90s of swings in the XRP value since mid-2018, which he found surprising. As of right now, XRP is trading at 51 cents, up 0.36 over the last 24 hours, but down 2.79 for the last week. Despite this, the digital asset is still holding on to its gains of 36.5 over the previous month. While the cryptocurrency industry awaits the summary judgment in the Securities and Exchange Commission, SEC, lawsuit against blockchain startup Ripple, the case has taken a new twist that has the potential to greatly influence the ultimate conclusion. In instance, lawyer Bill Morgan stated in a tweet on April 7 that the SEC's expert confessed that Bitcoin, Ethereum, and Ethereum, ETH, prices had been responsible for up to 90s of changes in the value of XRP since mid-2018. If the SEC's expert premise is correct, he believes Ripple is indirectly allowing the value of XRP to be impacted by Bitcoin and Ethereum price movements. As a result, the SEC aims to support the allegation by giving proof that Ripple's pricing announcements affect the value of XRP. Significantly, Morgan's theory is supported by the fact that Bitcoin's value changes affect the prices of the majority other cryptocurrencies. Morgan also said that the notion that Ripple's large XRP holdings indicate centralization of the XRP ledger and that XRP qualifies as a security remains. It's worth mentioning that Ripple is being sued by the SEC for selling unregistered securities in the form of XRP coins. As part of its argument, Ripple is appealing for unsealing of Hyman's speech papers, where the regulator described Bitcoin and Ethereum as securities. Surprisingly, Morgan agreed with the SEC's conclusion that investors relied on Ripple's legal efforts to win the SEC complaint. The attorney further highlighted that investors do not expect Ripple's commercial activities to make money from XRP, but rather that the business would prevail in the SEC action. Paradoxically, the SEC may be accurate about investors depending on Ripple's efforts, but not because of Ripple's commercial efforts or XRP sales, but because of Ripple's legal efforts, which will defeat the SEC's case if it is successful, he added. Jeremy Hogan, another pro-XRP lawyer, projected an unexpected conclusion for the lawsuit based on Morgan's words. Hogan predicted that if the presiding judge opted to split the baby, she may determine that XRP sales after mid-2018 were not securities, since the SEC acknowledges that Ripple's activities during that time period had no impact on the token's value. If the judge in the Ripple case wanted to split the babies, awful term, isn't it? She could find that sales of XRP since mid-2018 were not securities, since even the SEC admits that Ripple's activities had absolutely no influence on XRP's price at that point in time. He remarked. Hogan also mentioned the potential consequences of such a judgment, implying that Ripple may be compelled to pay a fine while continuing to operate its company. Moreover, since XRP is the only cryptocurrency with a defined legal position, Hogan believes it may affect the listing of digital assets on multiple trading platforms. Nonetheless, uncertainty regarding the timing for the summary judgment remains. Earlier, several legal experts predicted that the issue would be decided in the first quarter of 2023. Ultimately, the decision of the lawsuit is likely to have an influence on the value of XRP and the whole crypto industry. In the weekly chart, XRP is now trading at 51 cents, up roughly 1